Hi, this is Kathleen Bonzik. Is a person able to file a lawsuit alleging disability discrimination without actually having a disability? Would that person be subject to a motion to dismiss? The answer is that it is possible for a person who does not have a disability to ultimately, based on the facts, be successful in a disability discrimination lawsuit. Why is that? The law that is governing here at the federal level is the Americans with Disabilities Act, and it was enacted back in the early 1990s, and it was intended by the United States Congress to protect applicants and employees, a discrete and insular minority, a group that has been subject to discrimination in the workplace, from disability-based discrimination in employment. But the way the statute is written is very interesting because, in addition to affording applicants and employees who have disabilities with coverage, it also protects potentially other people in under one of two categories. First, the regarded as provision. The regarded as provision under the Americans with Disabilities Act states that basically, if you are an employer and you think that a person has a disability and you have a bias, prejudice, and therefore you do not provide that otherwise qualified applicant or employee with an opportunity because you have that bias, that person may still ultimately sustain a charge of discrimination with the EEOC and be successful in a lawsuit, even if he or she does not have that disability. So how does this work? Let's say an applicant goes in and applies for a position that he or she is qualified for, and the supervisor or the hiring authority believes that person to have HIV, and that person has a bias against Americans with HIV, and that is the only reason why the applicant's not hired. Even if that applicant does not have HIV, he or she could still sue for disability discrimination under the regarded as having a disability provision of the statute. There's a second way that a person without a disability could sue under the Americans with Disabilities Act, and that is the close relationship to provision. So in other words, let's say that an employee of an organization has put their name in for a promotional opportunity, and the supervisor knows that that employee has a child, let's say with autism, and is biased and believes that the employee should not be given this promotional opportunity because of some belief that he or she may have to take off too much time to care for that child. Under the under the close relationship to provision of the ADA, that employee could ultimately sustain a charge of discrimination, have a finding in their favor by the EEOC issued, or could sue and ultimately prevail in a lawsuit under the Americans with Disabilities Act. This is Kathleen Bonzik. Thank you very much for watching and listening today.